Okay, well, happy Monday, everyone. What a chaotic Monday it's been already. And my guess is it's going to be even a little more chaotic over the next few weeks. But today we're going to talk about something that's not about markets. It's more about planning and having a well thought out plan, and not just your investment management, but also your financial plan. And for many of you may have heard me talk about the need for a living trust. And I realize, not only me personally, but several of my clients, when COVID hit, there was a lot more of, I really don't have everything in line. If I were to get sick from COVID, who would be the one to make decisions from a medical perspective? Who would make decisions on a financial perspective? And there were a lot of culminating things going on with COVID that it really brought up the importance of having a living trust. And for many of you, you've heard me talk about that. I want to give a brief summary, and then I also want to talk to you about who I have as a guest speaker. But one of the things I really try to talk about with our clients, especially in the state of California, is not only the need for a living trust, but making sure your living trust is up to date. I always say it's easier to tax the dead than the living, which is why it's important to have a living trust. The state of California is definitely not a state flush with cash. So if they can find a way to extract money from dead people, they will. Okay. So a living trust is one of the few things that are very easy to do to avoid having the state get their claws in our assets. That didn't come out right, but you know what I mean on that. So typically, and again, Patrick, I'm going to have you probably fill that in a little bit, but the typical cost to go through probate is 4 to 8%, somewhere in that range. A living trust is a document that avoids probate that needs to be set up and established. And what it really does is it's your will with kind of what I would call an umbrella. I may be oversimplifying it, Patrick, but a lot of people say, well, I have a will. I'm like, well, that's great, but that doesn't avoid probate. You need a living trust. On top of that, when you have a living trust, you need to make sure your assets get into the living trust. I can think of instances where I had a client, it was, I don't know, 6-7 years ago, former HP guy. He actually refinanced his house with the credit union, and they often don't refinance as the living trust. You have to move it out of the trust and back into the trust. Well, the credit union forgot to put it back into the trust. And lo and behold, it's not as if, this is something that a lot of people pay attention to. I think it was maybe a year later, he passed away. And now his largest asset went through probate. And it was a very exhaustive process. So it's definitely important to understand. That's usually, for most of us, I call us normal folks, the most important thing that we own is our primary residence in the state of California. There is not a way to avoid probate if you don't have it in a living trust. I've had your IRAs automatically avoid probate. They're in a trust in themselves. So you've heard me ask, who's your beneficiary? How do you want to structure this for your beneficiary within your IRAs, your Roth IRAs, your brokerage accounts? There are ways to avoid probate with a brokerage account, but your home is an asset. And Patrick, and you might have a difference of add some context, some color to that. Your home is one of those things that cannot avoid probate. I've had clients say, well, why don't I just attach my kid's name to it and then I can avoid probate? I go, oh my gosh, if that kid gets in a car accident and gets sued, that house is now an asset that they can be sued upon. So I really frown upon it. The second thing is, one of the biggest reasons people don't get a trust is the cost. And I totally get that. And well, none of us want to plan our death, because that's not a very fun, you might as well start planning your taxes in July. Nobody wants to do this, but it's important to start thinking about it and do it while everything's healthy and in a good situation. But the other thing why a lot of folks don't get a trust is the cost. And the cost is typically, I'm going to say $1,500 to $3,000. Lower on if you're single, higher end on the unmarried. And that's the other big hurdle to get over is paying all that money. So let me put in context. Let's say you own a home in California, hypothetically, $1 million. And it costs 5% for that asset to go through probate. Regardless of what you owe on it, you still have to pay a probate fee. And we'll just say roughly 5%. So you're talking $50,000 just for that to avoid probate. That may force someone to have to sell to be able to pay those probate fees. So a living trust will avoid that. You know, one of the things I've had over the last several years is I worked with a lot of attorneys that offer trust, and again, they're expensive. But I happened to meet this great firm that's actually locally based here in San Diego. And through our custodians, Fidelity, Schwab, TD, we're able to provide a discount to our clients to be able to use their services. So now we're looking at a situation that the average trust is about $350 using Trust and Will. And really what they're using is more of a technology interface. It kind of, I almost want to say it's like a TurboTax. You answer a question, it'll take you here, it'll take you there. And then based on how you answer that question, it'll take you here. I'm again oversimplifying, Patrick, but they're able to get away from a lot of the time that a lawyer has to put in to putting a living trust together, and bring in technology to make it easier for you and also less costs, a lot less expensive. So that's kind of the main point why I want to talk about a living trust. I do want to kind of hit up on one thing I was reading this weekend too. I was reading this article about, I think we're all going a little stir crazy with COVID, in which obviously it's rearing its ugly head again. And we're seeing the COVID count at its highest level since July. I think we actually even surpassed that. And so we have it feels like this, I almost want to say like a hamster wheel that we're all on, just hoping that at some point this will go away, and doesn't feel like there's an end in sight. You know, I was reading this article about what's causing some people to maintain their sanity during this time period. And one of the things that they said is control is the number one thing, is helping people. They feel like they're in control. And the part of what gives someone control is having a plan. And for all of my clients, we have a financial plan, we have an investment plan, and hopefully that through all this chaos, I know that it's probably gonna get a little bit more chaotic, but we have a plan. And hopefully that this part of this estate plan, this living trust, is also part of your long-term plan, even your short-term plan. So with that being said, I really wanted to hand this over to Patrick and Andres. They're a group from San Diego. It's called Trust and Will. And I'm going to let them take the floor and dig into a little bit more details and piggyback on anything I said. And maybe I was wrong. You can correct me on this. And the other thing I did also want to point out, regardless of, I know we've got a lot of things going on with the election. The current estate tax limit is just about 12 million, roughly, a little over that. So it's 12 million for husband, 12 million for wife, 24 million. We don't have to worry about estate tax. And so for most of us, that's an irrelevant situation. Now, the one thing is they are looking at bringing that estate tax limit down to like 5.5 million. And all of a sudden that starts to add up your assets. That doesn't include any life insurance policy you have. And it's regardless of what you owe, it's all part of your estate. So it's something to kind of be aware of, is that roughly $5.5 million threshold. So like I said, with that being said, please let me hand this over to Andres. Please take the floor.
Great. Thanks so much, Jody, for having us. And thank you guys for your time. So name's Andreas. We're here with Trust and Will, and have Patrick Hicks, who is our head of legal. So he's an attorney. And first and foremost, Jody, I think it's amazing for you to kind of have so much importance in estate planning, kind of like what you talked about with control. It's a matter of having a plan in place. And if this year has shown us anything, we need to be prepared for the unexpected. So to kind of your point, when it comes to cost, what we've done is created a modern platform for estate planning where you can kind of do it on your own, or you can have attorney support, walk you through the process, and pay a lot less than what you would with an attorney. What we'll talk a little bit more about today is the nuances of estate planning. So some of the points that you highlighted correctly, Jody. So thanks for bringing those up. It's why is probate so complicated? How can we help avoid it? And then on top of that, what are some very important documents like a power of attorney, a living will, a HIP authorization that are also included in the estate plans that we offer. So thanks again for having us. Introducing Patrick Hicks, and he'll kind of take it from here.
Thanks, Andres, and thanks, Jody. Yeah, I think you raised some incredibly important points, and one that it's still frustrating to think about in times, but it's hard to not think about at the same time, is the impact that COVID has had in the last 6 months, 7 months now, on how many people are having to reconsider their estate plan. And it's been just an absolute eye opener in so many ways. But just focusing in on estate planning, just the importance of having a plan in place, but also the importance of having a plan in place for your healthcare and your medical decisions, with the number of people concerned about potentially needing drastic medical treatment. It's become something that people are now facing these questions that they may have previously thought, I don't need to worry about this yet. This isn't going to affect me right now. And then it's a very vibrant and tragic example of how we all should be prepared every single day, because we truly don't know when we're going to need that plan to kick in. And so it's important not only just to have a plan, but to have a plan that's up to date. A lot of people in early months this year realized that they have a plan, but it's 10 years old and it doesn't do any good because the people they've named to make medical decisions for them are not available. They're not around. They aren't accessible, things like that. Or maybe they had 2 people named and now they're realizing I need to have a few more backups here. So again, while it is a kind of a tragic reason to think about the importance of estate planning, it really is a fantastic example about why it is so important for everyone to have a plan in place. And we at Trust and Will, we've worked hard to make it easy to create a plan, have an affordable plan, and have a good quality plan, something that you could previously have one or the other, but we've kind of leveraged technology to make sure that it's easy to have both. And so I'm happy to be a part of Trust and Will to be leading this as well. And then, so Andres, do you want to walk through this? Do you want me to take this, or?
While you're working on Andres, I think he's trying to work on that.
Oh, you, Patrick.
I have even personally have done a living trust for our family, and we've seen, who marriages dissolve. So we had family members take over if something should happen to us, but then their marriage didn't pan out so well. So then it's like, well, that changes kind of the next thing. So you don't really think about it, but then we had to alter our living trust. And then we've done a lot of things too on managing our kids and what happens there. And I'll let you kind of get to that point, but there's a lot of things I've done. I'll share it with you guys for those of you that still have young children. So why don't if you want to go ahead and go on with that, I'd like to pipe in a little bit on because the other, I said there's a lot of reasons why people don't do living trusts. A, they want to plan on death. B, the cost. And C, they don't know what to do with their kids. They can't decide who they're going to name as guardian of their kids. So they just kind of stall, or maybe it's an excuse to stall. So maybe if you could add some input there, that'd be great, Patrick.
Yeah, that's, I'm happy to help. It's unfortunately all too common. And we can definitely get into this, but one of the reasons I think people think about like, this is difficult is these questions are hard. But what I like to kind of push back on is it's hard because it's scary, and that's also why it's important. But that's not really a good reason to think this is too much for me to do right now, because these are necessary tasks to really go through. So if you're scared or feel uncomfortable or stressed about this process, that is normal. Most people feel that way, but that should really motivate you to really push through it at the same time. So it's not going to make it easy, but it's not going to mean that you shouldn't do it either. So let's start with the basics. There's a few different documents you might encounter as part of an estate plan. And you've probably heard of some of these terms, but one of the most basic ones is a will. And so what is a will? A will is a legal document that controls the disposition of your assets after your death. It determines who gets what when you die. If you have a will, you're called dying testate. And if you don't have a will, you're called dying intestate. And what the will does is it helps you set your own preferences for where assets go. If you don't have a will, your assets are still distributed, but they're distributed through the process of intestacy, in which case the state laws decide where things go. The problem with having the state law decide where things go is you might find yourself in a situation where things may not go the way you want them to go. For example, if you're married, have 2 children, you might find that your 2 children each receive 1/3 of your estate and your spouse only receives 1/3. Sure, it all stays in your family, but most people don't want their children to receive an equal share to their spouse. So it's critically important to have a will. The process of administering a will on the next slide, this goes through probate. We've heard probate mentioned. Everyone's familiar with probate. Jody has mentioned probate. Probate is a judicial process to administer a will. So it takes the document, the judge looks at it, says this will is valid. It appoints the executor, says you now have the authority to carry out these instructions. Now go to it. The role of the executor: establish the validity of the will, collect the assets, pay debts, pay expenses, pay taxes, and then distribute the assets out. It's a fairly straightforward process in description, but it is far from it in actual practice. Probate is expensive, time-consuming process. Right now in California, you're looking at probably 24 months is reasonable in most counties before your probate is going to be closed, and that's with no disputes. The cost of probate in California is astronomically high. A $1 million asset, a house, and this, even if you have a mortgage on it, you can ignore the mortgage, but if you own a $1 million house, you're going to have up to $50,000 of probate expenses that have to be paid somewhere. So you frequently have individuals who go through probate and their spouse has to take out a mortgage or liquidate assets, or pull from a retirement account, something that may not want to do in order to pay these statutory mandatory probate fees. So with probate being so bad, one of the ways to avoid probate is the use of a trust. On the next slide,
And really quick on that, Patrick,
yeah,
I'd love to just add a personal experience, and I think, Jody, you do a great job of just sharing experiences. So before I came over to Trust and Will, I spent roughly about 13 years in private banking here in San Diego. And I can tell you guys how often it happened that clients just never set up their trust, and I would set up the estate accounts for them on the bank side. And literally they would sit there for roughly 12 to 16 months and they can't touch it. It's just tied in there, and you can access it for distributions to beneficiaries, people that need the money. So just to double down on the importance of helping avoid it, especially here in California where probate is expensive, it's complicated. And I think this is a really good segue to talk about the trust. So just wanted to add that on there, Patrick.
Thanks for that, Andres. Yeah, I've in my professional practice, I've actually seen some absolute horror stories, which I would love to share. But I think the real takeaway is probate is bad, and you'll hear that in some form from anyone you talk to. So probate is bad. It's probably as boiled down as we can get to. So probate being bad, people sometimes think, well, what can I do to avoid probate? Jody mentioned earlier that the living trust is really it's the key way to avoid probate. It's not the only way. There are some other ways to do it, but the living trust really is the key way, and it is, especially in California, the central document in almost every estate plan created. But what is a trust? A lot of people have some working knowledge of what a will is, but even with a trust, even if you have, you've seen it referenced in, Hollywood movies or TV shows, a lot of times people think of it as, oh, these are trust funds and these are extremely wealthy individuals, but it's really not so, not that way necessarily. It can be, but it doesn't have to be. A trust is really a legal arrangement between several parties, and those parties are the trustee who manages the assets. They're kind of like the CEO. The person who creates the trust, and the beneficiary. And who those parties are kind of changes over time. But the key with the trust is that by dividing that into who owns the asset and then who manages the asset and who the beneficiary is, by splitting that up through some legal magic, you can avoid probate, because technically the trust never dies, even though I die. Therefore, my assets and my trust don't go through probate. Sounds really simple, and in a lot of ways it is. But a trust gives you a lot of control over assets. So not just allowing you to avoid probate, but it does a lot of things that a will can't do. A trust gives you more control over when and how assets are distributed. I think we cover this on the next slide as well, the difference between a trust and a will. So wills are simpler, but trusts are a little more complex. They give you more control. They don't have to be hard, but they let you do a lot more. They're more powerful tools. Wills let you name guardians for your kids and pets. Trusts don't do that. It's a critical step, but a trust is just not used for that purpose. So since a will does something that is necessary and a trust doesn't do it, you typically see a will and trust paired together. So if you create an estate plan that involves a trust, there's also a coordinated will that goes along with it. They kind of belt and suspenders approach in some cases, but they really do different things. And so it's important to have them both, not just one or the other. But otherwise, the asset, they do a lot of similar things in terms of determining when and how assets are distributed. Trust can give you a little more control over that to make it more personalized to your needs. Maybe you have young children, you don't want them to receive all of your assets immediately. Maybe you want to stagger out distributions until your kids become 35 years old. Maybe you really want your children to study abroad, and so you want to add some provisions that say, I'll give you an extra $20,000 if you study abroad. I've seen all sorts of things, and it's really as personal and as customized as you want it to be. So
Yeah,
trust.
I'd love to add into that. I mean, I've seen a lot of kids inherit assets when they're 18 years old and they're not ready for the money at 18. And typically that's what happens if you don't have a trust. They'll hang out there until they're 18 and have full access to it. I think for me personally, I'm assuming my kids are the worst kids in the world and they're going to be just statistically the norm. Statistically, when kids inherit that money, it's gone in less than 2 years spent. I would assume my kids do the same. I'm not going to assume they're above average on anything. So I personally have it set up so that my kids don't receive, or they can't have the assets till they're 35. I put a lot of rules into it too. Some simple things like maybe a periodic drug test is good just to make sure the money's not going up their nose or in their veins. If they're going to do that, then I'd rather give it to a charity. So I've done a lot of things to kind of plan for the worst. And, it's interesting, Patrick, that you bring up the age of 35 and they say, this is for men, not for women, but they say that the male brain fully matures at 35. So that's where I've read several of these articles. So I kind of said, okay, 35 sounds good. So, I can always lighten it up if I feel like, okay, my kids are responsible and they're on the right path and I don't need to put all these strings attached. Then that would be one thing. But again, for now, I'm just going to assume I've done a horrible job parenting and my kids are rotten. And I, again, can kind of lighten it up a little later. So there's other ways.
Yeah.
I've seen some people say they've got to do certain religious things before they have access to the assets. I've just unfortunately been on the other side where I call them trustafarians. And those are kids that really kind of wait around for the money to land. And I really wanted to personally avoid my kids being in that predicament. So I tried to kind of foster it so they couldn't wait around for the money, assuming I'm dead, of course. So, yeah.
Yeah, and I don't think it has to do with your children necessarily being good or bad, or good with money or bad with money, or raised properly or not. And all those things certainly relevant, but money's a tough thing, and a shocking change for a child when they turn 18 to suddenly inherit a lot of money may lead to some poor decisions. Maybe they're trying to invest their own money, but they're not doing it in the right way. Or maybe they're thinking, you know what, I'm going to start a company. I'm going to be the next Facebook. 2 years later, it's gone. Maybe they're just driving home and they, run a stop sign and they hit someone and then they lose all that money in a lawsuit. There's a lot of things that happen that aren't necessarily poor life decisions, but may not be what you want to happen to the inheritance that was intended for your children.
Exactly.
The other thing that I think is important to point out and is often overlooked is that these restrictions on when children can receive assets, these are kind of the discretionary distributions, if you want. So most trusts are set up so that necessary expenses are paid for on an annual basis. So if your child has a healthcare need or educational expenses, typically those are going to be covered regardless of their age and regardless of conditions. but it's the extra money. Maybe your child wants to receive some money to purchase a house. That's discretionary for the trustee. In most trusts, they can say, yes, this is appropriate. It's going for a good purpose. I'm going to allow it. But if your child wants to go on a cruise around the world, maybe that doesn't happen until they get to age 35, and then they get a partial distribution check paid out, things like that. So these kind of rules and restrictions you put in place, they're not absolutely binding the hands of your beneficiaries. It's just kind of helping protect and preserve your inheritance to make sure that it's able to support your children throughout their lifetime, not just to enable them to take one bad decision when they turn 18. Because I am glad I didn't have that, because I feel like I would have probably made some different life choices if I had suddenly had an inheritance when I was 18 as well. So,
Patrick, I had a question from someone asking, let's just say today I wanted to completely redo my trust. Does it need to be in force for any period of time before it's active? Say I die tomorrow.
No,
Today, die tomorrow.
Yeah, that's a great question. No, not at all. You can, as long as your trust is validly created and holds assets, it's immediately effective. There's no issue with it having to be in effect for 6 months or 3 years or anything like that. There can occasionally be some tax provisions, but not for the type of trust that most people are using in their estate planning on the screen, known as a revocable living trust. It accounts for 95% of the trust used in estate planning, and there's no minimum period, holding period, or anything like that. Okay. It is important that it's fully signed, and it does need to hold assets. So when I say hold assets, it needs to be the legal owner of assets. So if you have a house, you should update your deed. If you have a bank account, you should update the registered owner on the account to list the trust as the owner. So that can take a little bit of time to get done. It's just an administrative process. But as long as that's done, there's no other time requirement.
Cool. Okay.
And that's actually a great segue, because the other type of trust that you'll occasionally see is something called a testamentary trust. A revocable living trust, which is the type of trust we've been discussing, it's created during lifetime. The revocable part means you can revoke it, you can amend it, you can change it over your lifetime. And the living part just means it's created while you're alive. That's the type of trust that most estate plans use. Again, I said 95%, and it's probably more than that, actually. 95% of the trusts used in most estate planning are revocable living trusts. The key is those do avoid probate. A testamentary trust is different. It's actually created under your will. So your will would say, upon my death, create a trust, put all of my assets into that trust, and then here are the rules of that trust, essentially. So you can still have all the same distribution provisions. You don't want your assets to go to your children until age 35, but it doesn't apply during lifetime. It only applies after death. There are a couple of drawbacks to that approach. Because it's not effective during lifetime, it kind of limits, or in some cases eliminates entirely, the ability to avoid probate. The other thing is that it kind of leaves you unprotected in the event of any incapacity or disability during your own lifetime while you're still alive. There's no benefit for you in terms of someone else making decisions to care for you under your trust. So testamentary trust can be used, particularly if you're going to have a situation where it's an urgent situation and we don't have time to set up a revocable living trust. But in most cases, a revocable living trust is going to be the preferred option. And there are some other types of trusts you'll see that are specifically used for various types of tax planning or charitable planning. And then there's some that are used for other purposes, like a special needs trust. If you have a child or a beneficiary who receives supplemental government assistance, a special needs trust can help ensure that they don't lose their eligibility for that support due to receiving an inheritance from you. So it's a great option if you have anybody in your family, any beneficiary, any children who receive assistance, to consider a special needs trust as a specific type of trust for your situation. And then, we started off earlier talking about COVID and how it's impacted a lot of people. And one of the things that people have really started to focus on is the impact of their estate plan in terms of their overall health. And what happens if they are incapacitated, they're on a ventilator, they're in a coma, they're medically induced, they're unable to speak for themselves. Who speaks for me? And those are all important decisions that are covered as part of an estate plan, even though they relate before death, decisions made before death, they're still part of your overall estate planning, because it's preparing for a time when you can't speak for yourself. And so you create these other important documents, and we have them listed here. The three most important documents are a power of attorney, a living will, and a HIPAA authorization. And those are incredibly important documents. Most people have some familiarity with them. A power of attorney, sometimes known as a financial power of attorney or a durable power of attorney, it lets someone else make decisions for you regarding your finances, real estate, taxes, and other transactional information, everything except healthcare. So that could be someone paying your bills, paying your mortgage, paying your property taxes, paying your hospital bills, anything like that, entering into an agreement to anything, buy and sell property in your name, carry on your business, anything that's not healthcare related is covered by your power of attorney. A living will, which is sometimes known as a healthcare directive or an advanced healthcare directive, and sometimes known as a medical power of attorney, is kind of the inverse in that it only deals with medical decisions. So while a financial power of attorney is everything except healthcare, a medical power of attorney or a living will is only healthcare. So that lets you specify who can make medical decisions for you if I'm unable to make them myself. So, we always hear these risks of a bus going to hit me as I step off the corner. But if I do happen to get hit by that bus and something happens and I can't speak for myself, who can make decisions for me to say what treatment should be authorized and not, and what type of care should I receive or not? That one in particular has been subject to a lot of additional focus in the last 8 months. A lot of people had out-of-date medical directives or healthcare directives, living wills, that essentially restricted the use of a ventilator. And with the early knowledge that a ventilator could be critical to saving a life, there were people who were rushing out to update their healthcare documents and saying, I didn't mean to exclude all cases of using a ventilator. I just didn't want to be left on the ventilator if it was a form of life support where I wasn't expected to recover. So COVID has really opened a lot of eyes again to seeing the importance of how these documents are updated periodically, because medical technologies and medical situations change over time. Your documents need to evolve with those. And the last document, frequently overlooked, but very important, is a HIPAA authorization. HIPAA is a federal law. It protects your medical information. It ensures that your doctor can't share medical information with other people without your permission. And this is that permission. So if you name someone as your healthcare agent to make decisions for you about your healthcare, that person needs to be able to speak with your physician, get updates on your status, and make decisions for you. So you just need to go ahead and give them permission to make sure that their physician has no issues sharing information about you. That's the HIPAA authorization. Those 3 documents, sometimes collectively referred to as healthcare documents or disability documents, are incredibly important and frequently overlooked. With the advances in medical technology, recent studies are showing that 60% of Americans will be affected by a period of incapacity during their lifetime, whether that's their own incapacity or someone in their family or someone that they care for going through a period of incapacity. And that's exactly when these documents come into place. So the majority of Americans will need these documents in place, whether for yourself or for someone else. So the focus on estate planning is often on what happens after I die, but it's important not to overlook the focus on what happens before I die if I'm unable to make decisions for myself. So I truly, personally and professionally, I cannot stress the importance enough of having these healthcare documents in place. It's tragic when they're not in place, because these are the decisions that someone else has to make for you, that it can stick with them for years when they have these doubts and fears and worries of, did I do the right thing? Should I have pursued a different form of treatment? Did I pull them off life support too early or too late? And having these decisions made for yourself and making it easier for someone else to make that decision, that's worth more than any inheritance to a lot of people, to know that the decision they made was the right decision. And it is difficult to think about, but it's incredibly important to go through this process and have these documents in place. Let's see, Andre, do we have any more slides?
No, I think that kind of wraps it up. One question that we get often all the time, Patrick, is updating an estate plan. Can we talk a little bit about how often, what's kind of the process like? Because I remember when I was opening trust accounts at the bank, all the time people come and say, yes, here's my trust. I haven't updated and gotten back in front of my attorney in years. So can we just talk a little bit about the importance of that and what's typically triggers when a client should go in to update their estate plans?
Yeah, that's a great question. So we have kind of a simple way of referring to that you should update your estate plan after any major life events or every 3 to 5 years regardless. So a major life event, what is that? That would be, a birth, a death, a change in marital status, the most common examples. But even, a major life event, maybe purchasing a house, or maybe you're retiring, or anything like that. Or if you have any changes, maybe you no longer want the person that you named as executor to fill that role. Something has happened. That person there's a better choice, and whatever it may be. So anything that changes is worth updating your plan immediately. But even if you don't have any changes, you should update your plan every 3 to 5 years. And why? But it sounds like a way to generate business, but it's really not. It's important to make sure that your plan is always up to date. Laws do change, and it doesn't seem like they change every day, but it's really common to have some major law change every 3 to 5 years that impacts your plan. I mean, look at COVID and the people who wanted to change their plan. That even a 5-year-old plan, it suddenly is no longer relevant in terms of the healthcare decisions being made under a pandemic. Was it foreseeable? No. Arguably, maybe, but should you update your plan? Absolutely. But then we also have other situations. A lot of people have heard about the Secure Act, which is a recent federal law that changed the treatment of inherited retirement plans, specifically IRAs that may be inherited after a death. And so old plans from even 5 years ago were set up under a system of laws that is no longer in existence. And so that one major law change means that most people's plans are out of date. Even if you have a 5-year-old trust, it may no longer be set up to provide the benefits that you think it's going to provide. So every 3 to 5 years is a great way to make sure that your plan is always updated with advances in technology and the legal framework. And then additionally, anytime you have a major life event, just go ahead and update your plan as well. We at Trust and Will, we try to make it easy to update your plan. I've been on the other side. It was mentioned earlier, I'm an estate planning attorney by trade, but I've been in law firms where it's hard to get a plan updated. It's $5,000 to get it set up, and then it's probably $2,500 to get an update. And you got to schedule a few weeks in advance and come into the attorney's office 2 or 3 times and come in once more to sign it all. And it's difficult and it's a hassle. And a lot of people avoid updating their plan because of that expense and because of that hassle. And that's one of the things I'm most proud of working with Trust and Will, is making it easy not just to create a plan, but to ensure that that plan stays up to date. We make it easy to update a plan. It's $12 a year to have access to update your plan. And that's $12 a year. That's $1 a month. $12 a year, and you can update your plan as many times as you want throughout that year. You get the documents, you make a change, you print them or you have them shipped, and you re-sign them, and you're good to go. There's no appointments to be made. There's no going into an attorney. You don't have to find an appointment time at 10 o'clock on a Tuesday and worry about how do you get there. It's whenever you want, as many times as you want, $12 a year.
The other thing is, for a lot of you that work at HP or at a company that offers prepaid legal, that's a great program, and I don't want to totally say that's not a good opportunity. But I'm really excited that this is here, because Trust and Will, I think, is going to be able to provide what we need for our clients. I think the ease of it, the technology component is great. The one thing I would say again is, if you do get a trust done, please call our office, because we want to make sure we retitle everything we can that we have control over into the trust. Also, I personally have a copy of mine into the Beta Wealth Management website. I keep a digital copy of it. And the way I frame it is, and the way I have it set up is really essentially, my husband does not deal with any of our finances. So I want him to be able to have one place to go. So I have in our wealth management portal, I have a copy of our trust, all the healthcare directives, everything that's in there. I have also a copy of our life insurance policies. Anything my husband just would, it probably went in one ear, not the other, when I told him, we have a long-term care policy. He wouldn't remember that 10 years from now. So now he's able to log into our portal, find anything he needs. Also, if he and I were in a car crash together, our trustee would have everything in one place to find. And I think it's really important to help. I don't know if anyone that's on this call has gone through trying to help someone with all their accounts wherever they are. And it's a full-time job. And the easier I can make it upon my trustees to find it all in one place, I do. And the other thing I do is I also keep a list of my passwords. So they're somewhat transcribed, but they're in there. And I do that because that's the next big hurdle is, okay, how do I get to this? Oh, I don't know the password. Well, you can't talk to us without the password. So, I try to kind of think about how my 12-year-old would be able to find his way around. And if something happened to my husband and I, not that he's our trustee, but I'm just saying, trying to keep it simple enough that he understands it. The other thing, when we were talking about having a living trust and I've had a lot of clients that they realize that all the people they've named as trustees have all passed away. So trying to figure out who to name as a trustee is also an important aspect. So one thing I was going to say, after we get off this call, I'm going to send everyone that's on this call, it's an invite to Will and Trust that'll give you the 10% discount. It's an advisor discount that you'll have. So you'll receive that email from me here in the next day or so. And you can start the process. I don't know if any of you want to elaborate on what that process looks like or what to expect.
Yeah, absolutely. So essentially with the relationship, Jody, is there's a link that comes through. The way we've essentially set up our platform, we don't charge up front. So if you want to just test out to see if this is the right fit for you, great. You essentially come in, you create a login, and then you're able to go through the full process, start to finish, of creating either the trust or the will. And what's most important too is we offer live customer support. So if you're stuck anywhere, you want to chat with someone, schedule a phone call, great. We have that available 6 days a week. And then I believe most clients are based here in California, in which we do offer attorney support. So if your situation's maybe a little bit more complicated and advanced, you're able to go through the full process with an attorney. And it's really unique. You actually get access to a licensed attorney here in California for a full 12 months. For a married couple, it's $6.99, the full trust with all the documents with the attorney with the 10% discount. So that's kind of how the process works. And if you guys have any questions, like I said, we have that live customer support 6 days a week. Once you actually go through and finish the process, the trust or the will gets actually shipped out to you here from San Diego. And then we make it very easy on next steps. So what do you need to get notarized? If you got a trust, we provide a very comprehensive trust funding guide to ensure that you title the assets under the trust. And we're there to help you as well if you have any questions on that process as well.
Couple questions. The trust document needs to be notarized. And Rami is a notary, so if you need her to notarize anything, she'll just work for chocolate. I'm kidding. But she'll help notarize anything that you have. I have a couple of questions here from the chat room, and one is if we already have a living will, can we update it through them? And yes, you can. And how do you do that? What's kind of the process to update the trust through you guys?
That's a great question. So generally the process, it's just like Andres described, you go to you'll receive a link, but you go to the link, you sign up, you create your login information. And one of the questions you'll be asked is, do you already have an existing estate plan? And you just have to click yes, and you can provide a little information about that. And what that is doing is that's essentially qualifying to make sure that this is the type of plan that we are able to update. So for example, we have to have some things that match between the input and the output, if you will. So if you have a joint trust, we can help you create or update it into another joint trust, but we can't update your joint trust into somehow being a separate trust. It doesn't, there's a lot of complications that we can't do, but as long as you answer those questions and it matches what we can do, you can proceed and we'll update your plan. And instead of creating a new trust document, it creates what's called a restatement, which is just a legal term that basically means it's a 100% amendment. And so your trust would say, I, Patrick Hicks, I previously created a trust in 2004. I'm updating it and amending it as follows. And then it's the full trust, and it lays out everything brand new, the new language, up to date, matching current laws, just everything updated the way you need it to be.
Perfect. And The other question I have, I think this is a common question I can answer a little bit, but question is what cannot be named owned within a trust? So like I said, your retirement accounts are already a trust. Now that doesn't mean you don't name the beneficiary as a trust. There's pros and cons on that. Are there any other things that cannot be put in a trust? Hard assets, maybe like gold, gun?
It's a great question. So anything that has a title is a little bit easier because you just have to update the title. Tangible assets, things like property, there's no title, so it's just a little bit of a more complex situation. Typically what you do is you have a one-page document, which we provide as part of our trust funding instructions, but a one-page document that you just list, I own gold coins or gold bullion that I store in my home safe, or I have antiques that are of notable value, and you just itemize those and sign them, and they're in the trust. So you absolutely can own gold and tangible items. Retirement plans are the single most common question. And as you've correctly said, you don't put the ownership of the retirement plan into the trust, but you can put the beneficiary as the trust. You should consult with your financial planner if you have more questions, but you can set up the trust to be the beneficiary. It's pretty much the same with life insurance. You typically don't transfer the ownership of life insurance, but you can make the trust the beneficiary. The other asset that's sometimes a surprise is cars. Your daily driver car, you absolutely could list it in the name of the trust. The problem is a lot of automobile insurance companies, they don't have a good system set up to deal with the trust. And so if you transfer your ownership of your vehicle to the trust and then go to get your insurance updated, systems go haywire with the auto insurance companies, and suddenly they have the trust listed as an additional insured and all the beneficiary, and it just kind of gets complicated. So it's pretty common to just say, leave your cars out of the trust. I mentioned earlier that we have a will that's kind of coordinated with the trust. And so even if you have something assets like a car outside, those would still eventually go into the trust after death. So your will kind of comes along. Anything you've managed to leave out, it kind of sweeps it all up. As long as it's a small amount you've left out, it's really not a problem.
And typically to retitle the house, it's a quick claim deed. It's a form you can get online. I think they charge $50 to reassign that. So it's a little bit of homework, also going into all the bank accounts and us brokerage accounts and just retitling them. It's not the end of the world, but it is a little bit of an effort once you get that new trust up and running. But well, awesome. I know we have some other questions, but I think I'd like to end it here. And I like I said, I'll send you guys the link. Try to get that out today or tomorrow, and for you guys to start the process of this. And I'm really glad you guys were able to jump on today's call and talk about this. And I think again, it's really relevant considering the times we're in. So I appreciate it for both of you, and thanks for everyone for showing up today. And onward and upward. Thanks, everyone. Have a good week.